Hello everyone, welcome to the webinar this morning. This is an online version of the webinar that was given to SACOSS small business members around rights of their employees and how to manage some common HR issues. So we're doing an online version this morning for some to broaden accessibility. So look, I do encourage you, if you're watching, please feel free to take some notes, email through any questions, and we're more than happy to help you when we can. So I'll just start by sharing my screen. Okay, so firstly, I'd like to acknowledge that the land we're recording this on today as the traditional land of the Kaurna people, and that we respect their spiritual relationship with their country. We also acknowledge the Kaurna people as the custodians of the Adelaide region and acknowledge that their cultural and heritage beliefs are still as important to the living Kaurna people today. Just a bit about us firstly. We've been around since 1979 and we are here to assist vulnerable women and workers with their employment law issues. And part of our funding is that we're also able to offer assistance to small business employers. So yeah, I'm more than happy to be giving this webinar this morning to some of you. Oops. Yep, that's, as I said, yeah, free and confidential service to women and vulnerable workers who aren't members of a union. And we're funded by the state and federal government's SA unions, as well as some grants. And relevantly to the small business people attending this morning, we do offer training as well for your organisation. So if you're at all interested in some training, please get in touch and our training officer, Cass, can yeah, have a chat with you. I just want to start with the type of cases we see, especially in this sector being social health and disability sectors. You can see the range we get as a centre there, but especially in that sector, we do often get calls around workplace harassment and bullying, workers' compensation, and dismissal or redundancy. So I am going to be touching on those areas today. And yeah, so just to explain a bit again about the work we do, I should have introduced myself. I'm Kylie, I'm an industrial officer, and yes, it was my job to talk to people who are calling us for these issues. So the type of work that we do in relation to these kind of issues that callers have is we do unfair dismissals and general protections claim in the Fair Work Commission. We also do discrimination claims in the Fair Work Commission, General Protections area, as well as the Equal Opportunity Commission and the Human Rights Commission. We also advise on workers' compensation and other general queries like questions about contracts or entitlements. For example, you know, are you getting paid properly, what to do in a disciplinary meeting, all those kinds of things. So we do have quite a broad reach across all the different areas of employment law. Today, I kind of wanted to work through what would be a kind of a pathway, I guess, if you had an unhappy staff member working in a workplace that wasn't healthy in itself. You know, where do the problems start? How do they fester? And then how do you end up, you know, suddenly you've got a legal claim on your desk from someone who's gone to the lengths of filing like an unfair dismissal or a discrimination claim. So basically, if you start with a healthy workplace, you have workplace equity and respect. If you've got that in place, that's a tick. Then through to, you know, what entitlements do your employees have? Are they getting everything they deserve? Through to what is a fair supervision practice? And, you know, if you do have someone that you need to discipline in your office, what's a fair and equitable way of doing that? Finally, if you've done those things but things still go wrong, what does a fair dismissal or redundancy process look like? And, you know, what are the factors involved that employee would need to show if they were to file a claim? So all of these things were relating to your obligations under the Fair Work Act as well as discrimination laws. Okay, so starting with workplace equity and respect. Your obligations as an employer really are to provide a safe workplace and to provide an equal and respectful workplace. So yeah, I thought it would be helpful to look at this kind of big picture first, because as I said, if you have a happy and healthy workplace, hopefully your employees are happy and valued, and you can save yourself some work in managing HR situations. I think it's a particularly becoming more and more relevant and difficult in some ways with the environment we're in now, and lots of people are working from home, doing Zoom meetings. Home and work life is becoming more blurred as technology increases. And every employee has a complex personal life and history and a set of experiences and beliefs. So, how do you manage that combination of people where you've got people's work and life lives, blending more and more, becoming more integrated. Yet, you've still got to make this combination of personalities and histories work in a workplace in a respectful and productive way. Community standards are changing as well around, and conversations around what is and isn't acceptable. And, again, how do you make sure that you're keeping up with current standards of behaviour, as well as helping some people to come on that journey to become, fit in with what is expected of an employee in today's workplace. So as I said, we're going to be getting into, what are your obligations under the Fair Work Act and the federal and state discrimination laws. We do have a whole training course actually on this around bystander action and how to have a healthy culture at work, but I just wanted to start with touching on some of the important things. So the most important points are, what are the fundamental beliefs of you and your workplace, you as a manager? What are your beliefs, and how do you communicate those to your workers about the standards you expect at work? Bystander action is very important. That means that all your staff should feel supported and enabled and empowered to stand up as a bystander if they notice something not going right in the workplace, or if they, for example, overhear or are witness to an incident that is not appropriate, like for instance, a racist joke or a sexist remark. Do they feel empowered and supported to, like, hey, I don't really think that's funny, perhaps you could reframe that, or what do you mean by that? I don't think that's an appropriate thing to say here. So it's really important to have the structure and training in place that everyone A, knows what is and isn't acceptable, and B, knows that the reporting pathways, where do they go? How do they address something that happens like that? And see, that they do feel empowered, that they know that the workplace has their back, and it's clear to them what isn't acceptable. So, if you think about your most junior employee, for example, like, would they know who to talk to, who to report something like that to? Would they feel empowered to speak up in that way, even if it was perhaps a more senior staff member who said the inappropriate thing? And would they, know what is and isn't acceptable? What messages do you send with your actions and your examples? And are you, do you come across as too busy and too important to take those kind of concerns seriously? So I think it's really important to have a safe space at work where people do feel empowered to be able to talk about these things. And just the final point on that screen there, that says, if you see violence in your workplace, is your business. Again, we do have a different training package around that, especially making sure that employees are safe when they're working from home. But if you do have an employee who's affected, for instance, by domestic and family violence, you know, it really is your job to help and support that worker and understand that they can't leave everything at home. It often really affects their well-being and presence at work, and they are going to need that extra support to get through. Yeah, as well, you know, if you have staff working at home, you know, how do you make sure that they are safe at home? And there's ways you can have those conversations with staff members if you're particularly worried. Again, I'm not our training officer, Cass, who has a master's in education, is a really brilliant trainer. She does give a really in-depth training session around that. But look, even if you have a question around that, please feel free to get in touch and we can talk about it in some more depth. Okay, I'll just go back to sharing the screen. Oops. Okay. Yeah, so I did already go into a bit about bystander action, but being a bystander and reporting things that you see in the workplace, you know, that having that system in place really discourages the perpetrator, as well as it supports the victim. It helps to improve your culture. It's like having, you know, people on the ground to stamp out those sexist and discriminatory jokes or actions that just aren't appropriate. And again, there's different ways of being a bystander. If that person feels strong and confident, they can speak up in the moment and say it's not appropriate and respond to it directly, which is really powerful. Or they can at least report the behaviour and know that they're being heard. Again, yeah, if you're interested, there's a lot of theory behind this kind of structure. So if you're interested, get in touch and we can have a further chat. Okay, I'm going to go into workplace bullying and harassment now. I think, you know, we get so many calls about workplace bullying and harassment, and there really is a range of behaviours, I guess, that are defined this way. Under the law, it's defined as a repeated and unreasonable behaviour directed towards a worker or a group of workers. And it's behaviour that threatens, intimidates or humiliates a person or a group of people in the workplace that creates a risk to their health and safety. Examples of bullying behaviour include yelling, abusive, insulting, threatening or offensive language, being singled out, excluded, isolated or treated differently, the display of material that's degrading or offensive, you know, it still happens, but you know, the old porn in the work locker still happens, unfortunately. Ongoing attempts to undermine you and your work performance. So that can be quite subtle, but if someone's constantly trying to undermine you, or you've got unrealistic goals that really are bullying because they're just so unrealistic that, you know, it's impossible to meet them. Having reasonable requests for leave or training opportunities denied is another one. And finally, behaviour or language that belittles, degrades, humiliates you, especially in front of others. So again, often these things are repeated. However, depending on how severe they are, it could be one incident or it could be a build-up over time. So what is not bullying behaviour? Reasonable and fair performance management or disciplinary action that is transparent, measurable and directed at performance and not the individual. So that's really important for people who are owners or managers to understand that, yeah, I often explain it to clients who are feeling upset by some disciplinary behaviour. Of course, everyone feels anxious and upset when they're, you know, when something's gone wrong and they've had to go to a disciplinary meeting. But if you conduct that in a transparent and measurable way and really step through it slowly and fairly and make sure that it's directed at the thing that is done wrong and not the person, that will go a big way to, yeah, not having problems. Also, something that's not bullying is differences of opinion in working relationships, which do not lead to the persistent and unreasonable behaviour and are not bullying behaviour. So again, we do provide further training on all of these things. So if you're interested, feel free to contact us for more information. Okay, so the next bit of the presentation is that further step. So you've done what you can to have a equitable and fair workplace, but what happens if you've done that, but you get a complaint or a disclosure from staff around something that's happened at work? What do you do? How do you handle it from the moment that you're informed? So I will jump back and share my screen again. Okay. Right. So importantly, it's very important to act promptly and treat it seriously. I guess if you've got a number of staff, it may be hard if someone brings something to you. It might be only one tiny thing going on in your day, but to that staff member, it's probably taken a lot of courage to come forward and report it. So it's very important that you treat it seriously. Keep it confidential. Ensure a fair process. So don't judge before you investigate. Be conscious of the language that you're using in terms of being fair to both the person who's reporting it and the person who is alleged to have done this thing. For all parties, it's obviously not easy being on either side. No victimization, so don't target any one party. And yeah, as I said in the previous slide, be transparent. Let people know what's happening and how long the investigation will take. Very importantly, keep good records. Make sure you've got written records of everything that you do, all the meetings you have, conversations you have. That will be important if anyone does lodge a claim. And it's a good practice to follow up as well. Once it's resolved, check back in with the staff member and make sure that they feel like their complaint has been heard. So if you do have to do an investigation process, what is fair? So I think, like I said, everyone is different, but basically you have that obligation to maintain a safe workplace. That is very paramount to your duty to investigate. The investigation should be done as soon as possible after you're aware of the incident. You may like to consider a third party to conduct the investigation so that everyone knows it is fair and independent. Often it may be most appropriate to stand down the employee with pay while the investigation is underway. That is the employer who has been alleged to have done the thing. That way, you know, it's very difficult for that employee to be at work, and plus often the investigation it may be easier if they're not there. And obviously it's important to do that with pay because you cannot disadvantage them in that way. If you have to, when you're informing the work of the investigation, it's very important that you give them enough information that they understand exactly what that is alleged to have happened, and you know they need that fair opportunity to respond. So often we might get a call where you know someone's been called into the office on the spot and you know asked what's happened, and they're put on the spot and feel like they don't actually have that that opportunity to process what's happened and think about where they were and what they did. It is much better practice to set it out in a letter to really detail what time of day it was, where it was, what is alleged to have happened, and then give that employee you know 3 or 4 days to get some advice, really think about what happened and provide a written response, because as you can imagine, it's not fun being accused of something and people get flustered and don't feel like they have a fair opportunity to respond. And then you as an employer, if you're not getting all the information you need to make a fair decision, that can again lead to like an unfair dismissal claim if you don't have all the information to make that decision on. So yeah, once you've got all the information from the employee, genuinely take what they've said into account and then decide on a reasonable and appropriate outcome. I'll just share my screen again. So a fair disciplinary process, this is the, again, I've gone through this a little bit. So what a reasonable direction would include to attend the disciplinary meeting, but it's important that you give the person enough notice, and it should be within their regular working hours. It's good practice to offer a support person. You don't, under the law, you don't have to offer a support person, but if they request one, you should not refuse unreasonably, but really it's good practice to have one there. Like I said, give specific details of those allegations in writing, and provide that opportunity to respond. When you're actually in the meeting, stick to the specific allegations that have already been raised. It's not fair to the employee to bring up other matters. Ask specific questions, like, when you were interacting with that client, or, what did they say, or something like that. Don't just ask, well, you tell me what happened on the day of the 24th of November. Make sure they're not vague or open-ended, and allow breaks if the employee is getting overwhelmed or upset. This all goes into what is a fair process. Again, outcomes, don't make the decision before you have the meeting. You really need to genuinely hear what the employee has to say and take their responses into consideration before you make a decision. Follow it up with a written determination and consider the appropriate consequence. So that might be something like an informal chat about the way that their performance could improve. It might be an official performance improvement plan, formal warning, or if it's really not going to be resolved and there's serious misconduct, dismissal might be appropriate. So just to go in a little bit to the performance improvement plan, I would actually like to mention at this point, on the Fair Work Ombudsman site, there is a managing underperformance checklist. Sorry, I don't have a link, but you can have a look at this one here. It really does step through point by point about how to assess the issue, meet with your employee, and devise a solution. So there's both an initial steps and a formal steps checklist. And look, the more information you can have as a manager or owner, the better. There's so much on the Fair Work Ombudsman site. So look, if you find yourself in this situation, I suggest you go have a look to have those checklists. And if you've got these checklists on record after those discussions, then that's just going to really, give yourself a good record in case there are any future claims. Go back to showing the screen. Okay, performance improvement plans. They should include a clear pathway to improvement, and include details about support and training along the way, clear and defined performance metrics, and ongoing catch-up to discuss the process. So, you can't jump from 0 to 100 in a couple of weeks. It should be measured and fair, and actually something that the employee can achieve. We've had quite a few calls around this kind of thing. And so one that sticks in my memory was a client who was in trouble for being abrupt. She had an accent, like English wasn't her first language, and the way she spoke, she was told that it was too abrupt, and her manager had an issue with it. And she was struggling so much. She felt it was extremely unfair. She was just speaking how she normally does. But this performance improvement plan she got put on, she was so closely monitored that every email of her was checked. When she had a conversation with another manager, they'd be asking the other manager whether she said, like, hello and how are you today. It was really, really over the top. She felt extremely targeted for that, and that's going way too far. It's not not measured. Like, how do you really define if someone's being abrupt or not? B, the monitoring was way too close. It didn't give her an opportunity to feel like she actually had a chance of improvement. She already felt like she had a big old I'm getting fired target on my back, and it certainly wasn't reasonable. It just reached way too far. So look, that's one example. But really, I think just remember it needs to be fair and reasonable. And also in that client's case, she felt very isolated. She wasn't able to ask questions around, her duties, which again isn't fair. How are you meant to improve if you don't have an opportunity to ask questions? So again, check out those checklists on the Fair Work site, and hopefully you'll never have any issues like that. Okay. All right, so just to lead on to the next steps that we'll be talking about, what is the risk if my workplace isn't safe, equitable, and respectful? What could happen? What claims could my employee have? There's the unfair dismissal in the Fair Work Commission, or the general protections claim, which really covers the same ground as the Human Rights Commission and the Equal Opportunity Commission. It's where well, not all the same actually, but general protections is where you raise a workplace right and then you suffer an adverse action. And we'll get into that a bit more later. There's discrimination, like I said, in the Human Rights Commission and the Equal Opportunity Commission. There's a stop bullying claim in the Fair Work Commission, or if the employees actually suffered like a psychological injury at work, they could lodge a workers' comp claim, or they could make a complaint to Safe Work SA if your workplace just does not have the policies in place. So there's a various number of avenues that legal, complaints that could be made about your workplace if you've failed to create a safe and healthy workplace for people. Okay, terminating employment, the gritty end. We're going to go into a bit about the Fair Work Commission complaints. Around what makes a dismissal unfair, and also how to handle redundancy processes in a fair way. So hopefully we'll have some tips about how an employee might see it from their point of view, and also how you might be able to just keep yourself out of trouble and do it properly, so that you hopefully never get to the Fair Work Commission. Okay, so what happens if an employee lodges a claim? Likely the first you'll hear of it is literally getting an email from the Fair Work Commission when they've lodged their application. So an employee, if they've been dismissed, they have 21 days from the date of dismissal to put in a claim. And once you've got that claim, you've got 7 days to put in your response and give it to your employee, who would be called the applicant in this situation. From there, the Fair Work Commission will run a conciliation conference, and this usually happens around 3 to 4 weeks after they've received the forms. That process is meant to be kind of a managed but more informal way to resolve the complaint from the employee. So what happens is the employee, it's usually on the phone, the employee will be on one end, you will be on the other, and there'll be a mediator called a conciliator at the Fair Work Commission who's there to manage the process between two parties. And really, you're not there to argue backwards and forwards. The conciliator isn't there to decide who's right and wrong. It's more like the employee gets about a few minutes to put across their point. You have the same opportunity, and then from there, it's usually goes into private sessions where really you're talking about compensation to help resolve the matter so that it doesn't go further. And the next stage is more like a formal court type proceeding in the commission. At that point, you might need a lawyer. It might be a hearing that lasts a couple of days. There'll be calls for evidence and witnesses and all that kind of thing that you think of more when you think about going to court. So certainly it can be in everyone's best interest if a fair settlement is come to earlier in the piece. So I'll just go into now the factors that make a dismissal unfair under the Fair Work Act. So a dismissal will be unfair if A, the employee has been dismissed, and that might sound obvious, but sometimes it's not quite clear if a dismissal has taken effect or not. The dismissal was harsh, unjust, and unreasonable. It wasn't a case of genuine redundancy, and this is especially relevant if you're a small business. If a dismissal will be unfair if you didn't follow the small business dismissal code. So again, this is on the Fair Work. I'll go into this in a bit more detail, but yes, basically that gives you the protection that if you're a small business without a huge HR department, if you follow the code, it won't be unfair. So I'll go into a bit about what is meant by harsh, unjust, and unreasonable. I'll read through it there. So there needs to be a valid reason for the dismissal related to the employee's capacity or conduct. And sorry, this is the ways that it won't be found harsh, unjust, and unreasonable. So was the employee notified of that reason and given an opportunity to respond? Again, this issue around the support person, if you've refused an employee having a support person at any discussions about the dismissal, was it unreasonable? Have you ever warned the employee previously about their performance being unsatisfactory? And the final point there is around the size of the business. So it basically means that if you're a small business, a dismissal won't be unfair just because you may have missed like a procedural step in warning someone, for instance. So it's more like overall, the effect of the dismissal has to be harsh, unjust, and unreasonable for it to be found an unfair dismissal in the Fair Work Commission. So the employee needs to establish a case that they deserve relief or compensation. And meanwhile, the onus, if you've alleged that there was misconduct involved in the dismissal, you must show that that in fact happened. So that's the kind of bearing of the onus in these kind of claims. So here, again, like I mentioned, the small business dismissal code, look it up, have it, on your desk, be aware of it if you ever need it, definitely. The small business is defined as having less than 15 employees, including casual employees who are regular and systematic. And yeah, that 15 also includes the employee being dismissed and employees of associated entities. So the code, again, please look it up and have a look. It just sets out the principles and steps for you to go through and tick off around what is fair and unfair. And if you can show that you've got that code there, keep it on your file, tick it off, make notes, it will be a defence for you to a claim of unfair dismissal. Okay, so next, we're going to go into redundancy. So I'll go through the factors as well. I think if you're actually going through a genuine redundancy, you might have had advice around those processes, but it's a good idea. I mean, often small businesses, ones we hear about anyway, will have an employee ring up, be like, oh, I've been made redundant, and really what they've tried to do is fire someone, but in not such a direct way. But if you do that and it's not a genuine redundancy, the employee can file an unfair dismissal claim on that basis. So here are the factors. As a small business, you don't have to pay redundancy pay, but the process must still be genuine and fair. A dismissal isn't genuine if you still need the job to be done by someone else. Like you need to have the position disappear, not just the person doing the job. Often in awards, there'll be or agreements, there'll be requirements to consult with employees about the redundancy. So make sure, obviously you should know what award your employees are under. Make sure that you're following those consultation processes. And redeployment, it will be a non-genuine redundancy if you could have reasonably given the employee another job to do in your business. So, you know, it might be that they do need a little bit of training, but really you should be looking around and seeing if you can offer them anything else and having that discussion with the employee. Okay, so we are going ahead to general protections. General protections, like I mentioned, this is a claim in the Fair Work Commission. It's there to protect the workplace rights of employees. It includes freedom of association, so you can't discriminate against someone for taking legitimate industrial action or being a union member. It provides protections from workplace discrimination and against sham arrangements. So you can't, you know, tell someone to get an ABN if they're actually an employee. And one of those important workplaces, right, as well, is raising a workplace right. One of those are protections, I mean. So if an employee comes to you and says, look, I don't think I'm getting paid right, you can't take adverse action and dismiss them. I mean, I'm sure if you're tuning into this, you wouldn't be doing that, but you'd be surprised about the number of cases that we hear where that kind of thing has happened. So yeah, that's under Part 3-1 of the Fair Work Act. What is an adverse action? That's things that disadvantage the employee in some way. So dismissing them, injuring them in their employment, that is quite a general term. Could be their hours or cutting their pay, moving them to a different shift that doesn't have penalty rates. Adverse action is also discriminating between one employee and another. Refusing to employ a prospective employee on those rights as well, or discriminating against a prospective employee on the terms and conditions in the offer of employment. Just as we mentioned, discrimination there, I'll just go through as well, you know, what workplace discrimination is and what attributes are protected. So discrimination occurs when an employer takes adverse action against an employee or a prospective employee on one of the following attributes, being race, colour, sex, sexual orientation, age, physical or mental disability, marital status, family or carers responsibilities, pregnancy, religion, political opinion, or national extraction or social origin. They're the protected grounds under the Fair Work Act. So like you said, you can do the general protections claim. I mean, an employee could. They could also go to the Human Rights Commission or the South Australian Equal Opportunity Commission to lodge those complaints. There's different time limits for those. If they've been dismissed in the Fair Work Commission, it's only 21 days from the date of dismissal. It's 12 months in the Human Rights Commission. Oh no, sorry. I'll take that back. 6 months in the Human Rights Commission and 12 months in the South Australian Equal Opportunity Commission. So importantly, on those grounds of discrimination, there's a burden of proof on the employer to show that they weren't dismissed for one of those prohibited reasons. Okay, well, we've pretty much come to the end of our discussion here today. I just wanted to cover off on what we've covered. So we've talked about workplace equity and respect and having those real bones there on which to build a healthy workplace culture. We've talked about how to deal with workplace bullying and harassment. We've talked about fair supervision and disciplinary processes. And then I've gone and addressed fair dismissal and redundancy processes, or at least told you not what to do in terms of what is an unfair dismissal and what is a non-genuine redundancy. So look, I really hope that you've enjoyed the little webinar this morning. As I've mentioned, we do a consultation, fee-for-service consultation on your workplace policies, procedures, and your obligations. So if you're interested, please do drop us an email or give us a call. I'm more than happy to chat with you about that. And we also, I'll just share my screen real quickly. We also, these are the kind of packages we do as well. Recognise and respond to domestic and family violence, the equity and respect, preventing and addressing sexual harassment. And yeah, we can do online or in person. So yeah, give us a call. And there's some more details there where you can look at our website, get in touch with us on Facebook, Twitter or Instagram. So look, thank you very much for viewing the webinar today. I hope you've had some useful hints and tips. And yeah, like I said, please get in touch if you've got any questions. Thank you so much. My name's Kylie and I'm signing off from the Working Women's Centre. Thank you very much.